Most people think you can simply stop practicing law one day and become a mediator the next. But as my guest today explains, building a successful neutral practice can take years of credibility, relationships, and one very important marketing principle that he calls go out, get seen, get asked. Let's talk about what it really takes to build a mediation practice. Welcome to the Practice Playbook Podcast, your go-to resource for legal professionals, mediators, and entrepreneurial experts building modern, profitable, and purpose-driven businesses. I'm your host, Susan Guthrie, attorney, mediator, and #1 best-selling author with over 35 years of experience. I'm a former chair of the ABA section of dispute resolution, and I've helped thousands of professionals build practices they love through my books, coaching, and training programs. Each week, I'll bring you real-world strategies, mindset shifts, and behind-the-scenes insights to help you grow with clarity, confidence, and impact. Let's dive in. Welcome back to the Practice Playbook Podcast, where we share real strategies from professionals building successful practices in law and dispute resolution. Today's episode is for anyone who has thought about making the transition from litigator to mediator, or who is already building a neutral practice and wondering what it really takes to succeed. My guest today is Scott Zucker, a commercial litigator with nearly 4 decades of experience who has built a thriving mediation and arbitration practice. He is also the author of The Mediation Minute, Insights on Alternative Dispute Resolution. In this conversation, Scott shares what the journey from advocate to neutral really looks like, why credibility and visibility matter so much in building a mediation practice, and his simple but powerful strategy for getting cases as a mediator. So let's dive in. Here's my conversation with Scott Zucker. Well, Scott, I'm so delighted to have you here with me today. Thank you so much for joining me to talk with my audience.
Susan, it is a pleasure to be with you. Thank you for having me on. I can't wait for this conversation.
Well, and I know my listeners are going to love this conversation. I was just telling you that when an experienced practitioner is willing to come on and kind of pull that curtain back on what their journey was like as they establish their practice, I find those are among the most popular episodes because it looks like maybe magic happened from the outside, but those who are willing to share the hard work, that's the real magic. So again, thank you.
No, and none of these are overnight successes that people see. It takes a long time, and I'm happy to talk about that journey. It's a fun story to tell.
It is, and story is what you say. I always like to ask a guest to tell maybe their backstory, their origin story, because you spent a couple of decades, right, as a commercial litigator before stepping into mediation. I know that journey will resonate with a lot of people who are listening to this episode. So maybe tell us a little bit of your backstory.
Well, I got out of law school in 1987, so decades, it's true. It's been a while. Came out as a commercial litigator, started at a firm here in Atlanta, and worked there for 12 years before I left with a buddy of mine to start my firm here in Atlanta, the Weissman Zucker firm, in 1999. So I've been at this a while, and I've been a litigator the whole time. My nature is not necessarily as an aggressive litigator. I've always thought that I've been paced and deliberate with the cases that I've had to work solutions for clients. So I always think that I had maybe a little bit of a mediator background in me even before I became a mediator, but I spent 30 years, almost being just pure litigation. And I realized now we're talking into the 90s and early 2000s that this world of ADR was developing. And I was in those mediations and arbitrations, learning it from an advocate's perspective. And then eventually in the early 2010s, I started I guess, professionally being a mediator or an arbitrator. And that just came from years of experience being on the other side of the table. And again, always having that sort of perspective about myself that maybe I was more into conciliation of resolution than argument for dispute purposes.
Argument, our craft and trade as litigators, right? But you say that, and I know there are many people out there who are listening who are saying, wait a minute, that rings a bell for me, because it did for me. When you just said that, I got out of law school just a couple of years behind you in 1990 and went into family law, but was at a very traditional law firm. So was a litigator, litigated family law cases. But if anyone out there does family law, they know litigation is not a successful path for reorganizing families very often, right? Litigation can be very conflictual. So instinctively, I knew it wasn't always the right path for clients. And as a part of my makeup, I was the same as you. I always tried to settle the cases. I knew that if we could bring people to the table and help them find a path out without having to go hardcore litigation, it was probably going to be best for that family. So I know there are people who are out there who also have gone down that path of litigation, who are like you and I, we discovered it a while ago, ADR, but they may be in the place of discovering it now and wanting to make that change. But maybe you found something that I found is, yes, you'd been an advocate in mediations and arbitrations, but you're still an advocate.
Yeah.
Arguing is, you're still aligned with a client. You're still, in theory, arguing your client's points and or making your client's case. And so there is a big shift when you go to becoming a neutral. And it can be a real challenge when you've been aligned with a litigation perspective for a long time. How did you find it? What did you find as you made that change?
It's funny you say that because I find myself sitting on my hands a lot in a mediation, thinking that I should be more direct about my opinion concerning the ultimate resolution of the case, as if I was an advocate for either side. Sometimes it seems obvious to me as to how cases should resolve themselves, but sometimes it takes time for people to figure that out for themselves. And I'm a true believer in the self-determination process of mediation, that people do have to come to these resolutions by themselves, because then they find that the process has been fair to them to reach that resolution. But I have held my tongue on certain circumstances as the mediator, recognizing that there is probably a easier and faster solution through mediation than there would be through litigation. I hold myself out as an evaluative mediator, and that's from those 3, almost 4 decades of litigating, that I feel like I can support the parties in their process by letting them know what I think might be the resolution of their case, not what will be, because we're not judges, but acting as a neutral to give them some guidance as to what I've seen and the cases that I've experienced. So maybe that gives them a bit of perspective. And I have to think that maybe those years of experience may have helped me be a better mediator, because I do have that experience. And I think I come from that perspective of knowledge, even if that's sort of self-presumed after all these years. And I mean, you've been at it a while as well. I think inevitably, even if we didn't try, we've learned.
Yeah.
And it's our opportunity to share that knowledge with others and help them. And hopefully that's what we're doing in this role as neutrals.
Yeah, I think for me the magic was when I found a way to layer my experience, what I've seen in practice and in the 30 years of litigating before I turned neutral. I think it was when someone taught me the phrase, would it be helpful if I shared with you what I've seen, or something like that? Would it be helpful?
Yeah.
As opposed to, I will be honest with you, I was pretty direct in my first couple of years as a mediator. I don't know how much mediation I did in my first few years as a mediator, and more of what I was doing is telling people what they should do. Exactly as you said, right? If you've done it long enough, you kind of see cases walk through the door and think you know where they're going to end up anyway, right?
Yeah, I've had some incredible role models as an advocate at mediation to watch their style of of being patient and letting people come to their own conclusions. And sometimes it takes hours. I mean, sometimes it takes days in these mediations for people to let their guard down and start letting in the recognition that not every case is perfect and that everything they did was not exactly right. And none of us are perfect. And once you realize that some of these decision-making episodes that have happened that led to these disputes may involve some fault and some risk, then I think they open their eyes to the opportunity of resolution. And again, having an evaluative mediator, I think sometimes can be helpful. But look, I've also been in a situation where I've turned off that evaluative hat and just sat and listened and been a person that the party can talk to other than their lawyer to just express how they're feeling. And sometimes that's all they need too. And I mean, certainly in domestic, and I don't do any domestic. I applaud you for having the domestic work. Is sometimes you just need to tell your story, and I believe maybe that's a part of the process for mediation, the healing process that happens sometimes in mediation.
So important. And, I think it's that insight that very often people just need to be heard, and we can be that sounding board for them. And it's a completely different role than being an evaluative mediator. It's being the person who finally is hearing what their pain is, what their experience was, and that can bring about, as you just said, that shift to resolution once they finally feel that they have been heard. And I would imagine you, as I, have seen those cases I mentioned. We see people come in and we've seen that case before. We've seen something similar. So we think we know where it's going. But when we trust the process and the people in the mediation, the resolution is different than perhaps what we might have thought at the beginning.
Yeah, every case is different, even if the facts are similar. It's interesting that one of the things I talk about, and I've written about this in the book, and I know you'll talk about the book at some point, but these articles that I've written about mediation as both an introduction, an explanation, both for advocates and other mediators, is the concept of creative thinking. And that's one of the things about mediation that I enjoy a lot is people come in a room thinking sometimes it's only about the dollars to reach a resolution. And again, domestic is different because you have custody issues and personal property, things that have to be evaluated. But in commercial disputes, primarily, and certainly personal injury cases, it's something that's just about the dollars. And sometimes if you can get people, you've heard the expression rethinking.
Yeah.
That's when the brain starts working to, well, maybe if we do this, we can talk about a resolution that includes other elements. In a commercial side, sometimes we talk about rebuilding the relationship of a vendor and a customer, or a contractor and their clients. I mean, there's so many other opportunities to reach, and I use the word closure for these disputes by doing some creative thinking. And that to me is really the fun part. When you walk into a mediation, you don't know what's going to happen. And if you can be open-minded to creative thinking, sometimes it can find a solution that way.
I love that you say creative thinking, honestly, because one of the things for me that was appealing about mediation as I got further and further into my practice was that I don't think the law and advocacy is particularly creative, right? Our job is to take the facts and the laws and put them together and advocate in a way for our client's position and wants and needs and desires. And creativity could get us actually into a little bit of trouble if we get a little too creative. Whereas it's a real skill and benefit in the mediation process because the people do have that flexibility, the clients, to pretty much craft what is going to work for them, whether that ever would have worked in a courtroom or not.
I love sometimes judges from the bench will say, I'm governed by law to issue a decision a certain way. If you can exit this courtroom and do a mediation, you can create any solution that you want because it's between the parties. And that does open up the door to possibilities for people that otherwise they wouldn't have in court. You're exactly right. Otherwise, we're limited by the law. So,
Yeah.
I know your question about, what this journey was, and I sort of got a field there, but I started true mediation and arbitration work as an offshoot of my firm, I had the benefit of, since we had our own firm, as a service of our firm, I started putting out this service of alternative dispute resolution back in the early 2010s. Just in terms of you asking questions about building up the practice, it gave me the opportunity, still with my foot in the water as a litigator. I had also a toe in the water as a mediator, and I was able to balance the two and continue even to this day to sort of balance a little bit of that, as I'm still involved in practicing law as well as being a mediator. I know a lot of the people that may be listening think about, well, I'm just going to stop my practice and start the next day as a mediator. And that's very hard to do. That your circumstances may invite you to be in that situation, but if you can start moving into a mediation practice beyond what your normal law practice is, whether you're a litigator or commercial work or whatever, if you want to start doing mediation, I think it's great to put yourself out there to start doing a few while you're still practicing. Certainly economically makes sense to do that and build up your comfort and your confidence, your networking as a mediator. And that's how you slowly build a practice. I've been doing this now for almost 20 years with that little foot in the pool of water as the mediator, until last year I effectively joined Miles and doing it more of my practice now.
That's really so many people listening right now, their ears perked up when you were talking about this, because I think it's a very common practice paradigm that we have people like you, right, who spent decades building a very illustrious career as litigators, and then they start to straddle the two worlds. I like you're dipping the toes in two ways. I recently did a workshop with a bunch of colleagues who had been litigators for many years and who were now starting mediation practices. Most of the people in the room had been trying to transition or starting to transition for a few years. And we're finding the straddling difficult because they were very, very good and had a great pipeline of business for the litigation, but struggled to find the mediation cases to start to be known as mediators. So I'd love to have you talk a little bit more about what that was like, how you transitioned the clients from hiring you as an advocate to hiring you as a mediator, or did you do something different?
Well, yeah, it's a little awkward to be advocate for a client and then be the mediator for a client. So it really is it's been two separate worlds. It has
Yeah.
been two separate worlds. These are likely lawyers that I've known that know me as a litigator, that now know that I wear a hat as a mediator, that have come to me to help them resolve their cases because of, I'll phrase it, maybe because of my demeanor about managing cases, and again that evaluative approach that I advertise because of my experience at the bar now for almost 40 years, and that was sort of how to manage the two. But I will tell you, more than anything, and I think you've been great about this with all the webinars and programs that you've done about teaching people about marketing their mediation practice, and you'll laugh when I tell you this story, but I call it the go out, get seen out, get asked out marketing approach.
It's
And
like the dating approach.
well, that's what it was. This comes from one of my wife's best friends in college. Her mother told her, if you're ever going to go date, you got to get asked out. And so I've used that as a sort of a approach for the mediation. People need to know that you are transitioning to a mediation practice and that you're willing to take on that responsibility as a mediator, even though they've seen you for years as a litigator. And then you need to let people know that this is what you're doing and this is where your practice is going, so that they're willing to contact you to use you for that service. And it's not something to be bashful about. It's something to be very proud that a lot of litigators are like, I'm still litigating. I don't want to be seen as a mediator. But I'm telling you, this world that we're living in now, where there's so much negativity in the world of litigation, we need positive people to be mediators and neutrals and intermediaries to help get matters resolved. So if you have that skill set, I support people that want to do this because I think it's a really important job. And I think it will help the dockets of our courts. It'll help the legal systems in our communities. It's a really important work.
I've always told people that mediation, at least for me, is harder work than the work I did as an advocate, but also makes me feel better about everything that we do as professionals and what I do as a professional. I could go into a courtroom and litigate a family law case, and I realize I'm in a certain strata of practice, but I felt far better walking out of a mediation room with a couple that were going to be able to go forward and co-parent their family and have a better future than when I walked into a courtroom and did what I had to do in the courtroom in that aspect. So I agree with you. It's incredibly important. Also important is everything that you just said about getting out and being seen, or being seen out. But say it again for me, just so I love it.
Go out, get seen out, get asked out. I mean, it's
Okay.
a little juvenile on the dating side, but it works in the marketing side. Whatever you do,
It's
you got to
brilliant.
make an effort. I will tell you, another great mentor of mine always said, just show up.
Hmm.
And I will tell you that's inspired me with regard to the Atlanta Bar Association, where I've been involved in the State Bar Association. You've got to participate. You've got to put yourself out there to be part of the legal community in the ADR world for people to see you as a participant and a volunteer and someone they can go to and feel trust to go to help them with their cases. And that's true. I mean, we have so many needs in our bar community as well for those volunteers, and it's really fun. And I know you've been so involved in the ABA, and I've actually recently gotten re-involved in the ABA. I think what a great organization. Susan, I'm like, you're inspiring me by the things that you do. It's the same approach. I think we have the same attitude about how to build a practice and support our legal community.
And when you support the community and support dispute resolution, then we support that whole infrastructure of creating a better way for people to resolve their disputes, reach closure. I love that you call it reach closure because it allows them to close a chapter that we know is so, in whatever way, is so stressful for the parties that are involved. It's not stressful. We go home to our lives, at the end of the day, at the end of a mediation, at the end of an arbitration, even at the end of a litigation, although I think we take some of that stress home as litigators. I did. But for the clients, it really is closure. Importantly, one of the things that you've said about this new dating paradigm for our colleagues, I want them to realize the other thing that you said was actually being able to say to others who you now are, what you now do, and take pride in that, and let people know I'm a mediator because people, I think, I get this with a lot of my clients who are transitioning, say, off the bench or out of a litigation practice. Well, people know that I was a really good litigator. I think I have a great reputation. I had a judge who just said that to me the other day. I have a really good reputation as a judge. I've won every award. It shouldn't be hard to get clients. And it will be, in my experience anyway, unless people know you've shifted to a new area of practice.
Exactly. Yes. Yes. It's hard. It's a very busy community out there of lawyers and practitioners and judges and mediators. Look, mediation is a very big business now. There are a lot of mediators out there. You've got to distinguish yourself, and I think, especially the judges, I think to have that judge credibility, I'll call it the judge gravitas that makes them stand out. If I could choose between me and a ex-judge, a former judge, I'd pick the judge. Sometimes because I just their experience is by far overwhelming compared to any practitioner I know because do it every day and they sit behind the bench and they see things and they learn things. Anyway, so I mean I say to your friend who's the judge, go out there, let people know that you were a judge, but that you want to be a mediator now. That's pretty important.
Yeah. And you just mentioned another aspect of this is the experience and expertise. And, they're different a little bit. when you go from an advocate to a neutral. The expertise of being a neutral is a little different than being an advocate. And so, one of my big things about how you can start to let people know about your expertise as a dispute resolution professionals is thought leadership, and you excel at thought leadership. So tell us a little bit, because you have written extensively on, mediation strategy. That became your book. Well, I want you to tell us a little bit about the book, The Mediation Minute. How did you get started? Was it a strategy to put out thought leadership in that fashion, or did it come about in a more organic way?
More organic. I mean, actually, I used the same model as I grew my litigation practice because I became a writer and speaker about real estate law and construction matters to build my practice. So I took the same sort of, I thought the same marketing approach that I used to develop my practice all those years about writing about interesting areas of the law, speaking on interesting area of the laws. When I decided to do the mediation, I got involved and started speaking at the conferences and writing about mediation. So I found it just sort of a corollary of how I developed my own law firm and my practice to use the same methodology of building my mediation practice. And look, I love writing, and I think I express issues that are helpful for people, both again as advocates and mediators in that writing. I mean, we're talking about closure. I see so much psychology in the context of mediation. And it seems like such a fascinating area for me. So as I researched areas within the psychological aspects of mediation, I would write about it. And then that article would get published. And effectively, I took those 10 years of writing different articles on different areas and combined them into this book and, just put it out there as an opportunity for both advocates and mediators to maybe rethink themselves as to how they approach their mediations, some lessons learned from it. And this is for me, and I think maybe I've seen from all the writing that you do, sometimes it's easier to express yourself in the written word than it is, verbally. So I try to share these stories in the writing, sometimes a little easier than doing it, talking about it.
Well, and it's wonderful because your writing is an outgrowth of what I would call your avid curiosity about what is happening in that room as a mediator, what you're observing, the skills that you're bringing to the table, how you're seeing it play out for those. You're talking about the psychology. And isn't that really a hallmark of an amazing mediator? I think avid curiosity is really one of the gifts of a great mediator. But you've taken that and done what I think so many of our colleagues struggle with. You use that as the inspiration for your writing.
I think I sent you this most recent article that I did. It's just sort of funny. I think I was watching something historical about the Cold War and some quote that and I wish I had the exact quote in front of me. It literally, in a room full of gasoline, how many matches does it take to start a fire? And I heard that, and all I could think about was that expression in the context of mediation. I've been in a room where advocates are so aggressive and the energy of trying to beat the other side aggressively in this dispute made me see the fact that, if we picture ourselves in a room of gasoline and they both think they have the matches to start the fire, but they would engulf themselves and their client in years of dispute litigation and cost and stress and impact to their businesses, that sometimes people don't step back and think about the impact of that. So you talk about curiosity. I sometimes write these articles because there's a quote or a
Yeah.
spark of information. And I go, gosh, that so applies to what I see in the world of mediation. And then it's write an article. So I have to tell you, this other one I sent you is sort of interesting because I think it's an interesting topic for us to talk about. This quote of, is it really alternative dispute resolution anymore? Is it really alternative? Or is it dispute resolution? And
I
we've
like to
moved from
call
a
it
world.
primary dispute resolution.
Yeah, there you go. I mean,
Yeah.
it's something that we should be thinking about as not an alternative perspective to disputes, but almost that. Oh, I'm going to steal that. That's a
You can
primary. There you go.
EDR, primary dispute resolution. I didn't come up
Wow.
with it. Australia did.
Wow.
That's
Well, I'm
their
going to give you credit on that one, but there you go. I mean, to me, that's even by reframing what dispute resolution is, what mediation is as a primary consideration to help people with their problems as compared to litigation, and then thinking about mediation as an alternative to that process is sort of brilliant right there. So yeah, we're all in this together. I please share that to the masses because I think that's really important.
And you make another point that it's funny, I was just in a call before you and I got on to tape the episode talking about practice building for dispute resolution professionals. And you will never, rarely hear me say alternative dispute resolution professionals. I will always say dispute resolution professionals, but we were talking about building a practice. And one of the things that came up in that conversation was when you are a dispute resolution professional and you are talking or marketing your services, you're not just marketing your services, you are marketing dispute resolution because they are opt-in services. They are arbitration is opt-in. Well, it's opt-in at some point, right? They put it in
Sure,
their
sure. Yeah.
contract. They opted in at that point. Mediation, opt-in process. And so you're always coming at it from both perspectives of talking about not only why you're the best person to handle that particular dispute for these parties, but why they should be mediating it, why they should be arbitrating it, why some dispute resolution process should be a part of it. I want to really highlight what you said because I found it to be so true as well. So many colleagues struggle with writing because they have a hard time with the genesis of the idea. They have what I call blank page syndrome, right?
Yeah.
And
Yep.
it is hard at first, but maybe it sounds like you found what I have found. I struggled a bit in the beginning when I sat down to start to write, but I swear to you today I could look around this room and find a light switch, and that light switch could turn on an idea for me to write about something now, about dispute resolution or about an idea flipping the switch on an idea, and
There you go.
things come along, right? Things will come. I
That's the next
promise you,
title of
folks.
your article right there, flipping the switch on ADR. I love it. Or
Me too, on
DR. Yeah,
DR or
ADR.
PDR. I'll say it came from this
Yeah.
conversation. It's a muscle that
Yeah.
we start
Yeah.
to flex, and the joy of it is as we start to flex the muscle, more and more ideas will come to us, and it's very helpful for continuing the writing.
And I will say this in the context of that writing, and that blank page, that white page syndrome is a horrible thing to think about. And I've been a writer for years, and sometimes that white page just is horrible to look at, to think about putting your words on a page. But sometimes it's so overwhelming for people to think about writing their thoughts on something because they think they have to write the book, and they think
Yeah.
about it as, I got to sit down and write a 200-page book. How am I going to start? And I have used the philosophy, and this is really where this mediation book came from, is the compilation of the articles. It's just one bite on the topic, and then you write that article, you write that story, and then you come back the next day and you write the next story. Don't think about it as having to sit down and write the book.
The treatise on the topic.
It's something that comes over time, and that's the thing about this phrase, the overnight success aspect of it. These articles in this book, it took me 20 years to put together. The same about the practice. It doesn't happen overnight. It's every day getting up and putting yourself out there. It's every day being a mediator and learning from your own mistakes as a mediator too, and understanding how you deal with people and growing from that experience. You think that after almost 40 years of practice, I should know better in doing certain things that I do in a mediation. And then I realize, okay, I've learned another lesson about being more patient about this, or listening more about that, or whether we're going to have opening statements based upon the personality of the people, or whether I need pre-mediation statements, or whether I need, you learn, and you learn these sort of these elements from the people that you're working with as to what works and what doesn't work.
Yep. And every little step of that builds your skill.
Yeah.
Every article you might write about that builds as well because you're thinking about the process now. You're sort of, breaking it down. I will often write about things that happen. Of course, you never share any client details or personally identifying information, but the core issues are certainly things that you can talk about, you can write about, you can share in a program. And, I know one of the things that you are known for and that you value is the trust factor in dispute resolution, right? Trust is it's really our trade.
Yeah.
People have to trust us to get in the room. And what the writing does, what the thought leadership does when you're putting out that content is it allows people to start to trust you, perhaps before they ever even know who you are, know what you do, or might need your services or know someone who needs your services. But they see your, articles, they see the content that you put out, they hear you speak at something and they're like, yeah, that guy Scott, that stayed with me, something he said.
Well, you try that, but the bedrock to me of mediation, and I know you've talked about this, is the confidentiality aspect of it,
Mhm.
and people that want to share the honesty of their situations, the facts of what happened in any sort of the cases, if they don't feel that there's trust in that room, they'll never open up, and the case will never get resolved, and that's frustrating to me. So you're right. I mean, I think I work very hard to build, and we all do as mediators, build this sense of comfort and trust, integrity in the process, credibility in the process, because otherwise it just isn't going to work. And
Yeah.
I think that's true. And I think people have to. This is the other thing about the overnight success story. You have to build that credibility and trust and integrity story about you, and that takes a long time. Unfortunately, it can be lost very quickly, but it takes years to build. And I guess I've been fortunate that came here right out of law school in 1987, and have been part of the Atlanta legal community for almost 40 years. And people know you. They know they've been on the other side of the table from you in litigation. They know how you behave. They know whether they can trust you, and that's now led to the mediation practice. So it's something to be proud of, and I actually am pretty proud of it. And but I also really like to tell the story, and I appreciate the opportunity to do that. That people should take their time and work through the effort of doing this because it's important work, but it does take time, and the clients are not going to come overnight. It takes time.
Sure does. Like I was just doing a little research on one of my little AI friends, and it seems pretty consistent that at least professionals report it takes about 3 to 5 years to start feeling like you're getting your feet under you when establishing a dispute resolution practice.
And your little thing about I want to, even though we're all worried AI is going to replace all of us, I think in a mediation setting, there's a certain role for AI in our legal world as it happens. It's inevitable, but the human contact, the human ear to listen, the eye contact, the time it takes to work through a problem can never be replaced with AI. I think there's going to be a role for people that are neutrals in our world because there's always going to be disputes. So you just need people to be able to help you work through those disputes. And again, it's certainly contrary to my world as a litigator. I made my living having people have disputes and
Yes.
fighting them out and going to court. That was we billed by the hour for that purpose to let that happen. I certainly have not changed. Sometimes that's an inevitable reality to the dispute. It can't be settled unless a judge or jury hears it. But I think that the percentages are so high that the majority of these cases can be resolved through dispute resolution, and you just need the right people to help people get there. And we're
Yeah.
very fortunate, and certainly in the Atlanta community, but throughout the country, and the people that you meet through the ABA, there's some really skilled people out there that get the job done, which is great. And I'm learning from them all every day.
Well, and I know my audience is learning from you. The people who are listening, there's so many. I always call them the golden nuggets in an episode. There are so many golden nuggets in this episode, but I want to give you a chance to wrap up with me put you on the spot a little bit here, but if you were to give one golden nugget of advice to someone today who's struggling in those early days of that transition from litigator to dispute resolution professional and finding it a hard transition, as so many do, what would you say to them?
Well, I'd have to reflect on what I did to start my mediation practice, and it takes sort of obviously the goal of being educated and certified. I mean, we're even if you're a lawyer and you've been practicing for years, doesn't mean you necessarily have learned the skills of being a mediator. It is not the same thing as being an advocate and a litigator in the role of a mediator. So you have to learn. So there's great programs where you can be certified but trained for that. So if you're interested in it, you've got to get the training for it so that you are led on the right path of that. And then once you're certified, you can go to your courts in your local jurisdiction. And fortunately, in Atlanta, the metro area, with dozens of counties, and each have courts, and each of those courts have dispute resolution programs, and they're looking for mediators, and you volunteer to be on those lists. So you learn your skill and you will get cases through the courts, and then you can work your way up through other private mediation programs. But I think the court mediation opportunity is tremendous, so needed because of the overextended dockets of these courts. They need mediators to help them clear out these cases. So volunteer with your local courts, get the experience that way. And a lot of people are hesitant to do that, but I think that that's really where the training ground could be for a good mediator, starting with the court system.
No, I agree, especially, since the pandemic. I mean, our courts were already overloaded going into the pandemic. They built up a backlog during the pandemic, and I don't know how the courts will ever get caught up. And most of our judges in courts and court administrators, I have a lot that are colleagues in the ABA, are very pro mediation,
Yeah.
pro getting these cases. I love your story of a judge who might say, go out in the hallway. You guys can figure something out that's far different from what I'm allowed to figure out for you. So love that advice. I want to make sure people know how there are a few ways they can get your book.
I can show my
Yes,
book there?
please show
There,
it.
yes.
Yeah. So
Mediation Minute.
it's got the puzzle piece. I have to tell you, all mediators and lawyers, we always have our verbal shticks, right? That we talk about with clients. I always told clients in mediation, you never can decide, at least in a family mediation, one issue completely without making sure that all the other puzzle pieces fit together with it, because it is
Right.
a puzzle, not
That's what
right. So
and that's exactly right. It's all a big puzzle. Yes.
it's all a big puzzle. So if you're a puzzle fan, dispute resolution is going to be the way to go. What's the best way for them to get the book, get in touch with you, find out more?
Well, the book's on Amazon, and always interested in hearing people's suggestions for other topics that that they're may want me to write about, because I love writing about these mediation issues. But the book's available on Amazon. In terms of reaching out to me again, I joined Miles Mediation here in Atlanta. Now they're national,
Yes, they are.
and have just love working with them. I'm very proud of the fact that I think I'm your first Miles neutral to be
You
on your program. So
Yes.
I get cred for that. But anyway, I'm at Miles Mediation, and it's a great group. I think one of the things I'm learning about professional mediation groups like Miles that are out there is the opportunity of providing service to the the clients, not necessarily the litigators, but the parties, in terms of creating an environment where they feel comfortable for the purpose of the mediation. So I'm really impressed by all these organizations that have settings where people can come, feel safe, feel comfortable, get fed.
Yep.
There's coffee, there's water.
No one hates
They
getting fed.
Right, and there's a place for them to relax and be able to feel, again, I guess we were really use the word safe, for them to open up for the purpose of working towards the resolution. So it's been a pleasure to be with Miles, and a pleasure to be with you, Susan. Thank you for taking time to talk to me about this, and I'm always happy to talk to folks about how to build their practices and nuances of mediation and the journey. It's been a fun one, and I look forward to continuing that journey for a long time to come here in Atlanta.
Well, I encourage everyone to reach out, get the book, connect with Scott on LinkedIn as well. It's another good place. I will put links for everything in the show notes, as I always do. One little tip, guys, you've heard me say this before. One of the best things you can do for an author is leave them a review on their book on Amazon. It's how other people can find the book. So please do Scott a favor and leave him a 5-star review on the book and tell him why you thought it was a fabulous book. I'll be doing the same for the book shortly. And thank you for coming and sharing your experience. It is, as I said, the most accessible information for colleagues is to hear from another colleague that they trust, that has walked the walk and traversed the path. And there's so much here to support us. I truly believe that when we support other professionals and colleagues in having successful practices, being able to, feed our families and keep a roof over our heads by doing this work we love, we help dispute resolution thrive in a world that desperately needs it. So thank you for being a part of this.
My pleasure. Great words, Susan. You're absolutely right. Let that be an inspiration for people that listen to this and for their practices. I hope them great success.
Such a valuable conversation. Scott shared so many insights that I know are resonating with you. So before we wrap up, I always like to leave you with a few of those golden nuggets. Here are a few key takeaways. First, building a successful mediation practice does not happen overnight. As Scott shared, reputation, relationships, and credibility are built over years of experience and engagement within your professional community. Second, if you want people to hire you as a mediator, they have to know that you are a mediator. Scott shared his memorable marketing advice: go out, get seen, get asked. That means showing up in your professional community, participating in bar associations and industry groups, and letting people know the work you are doing. Third, thought leadership is one of the most powerful tools for building credibility. Scott's writing, which eventually became his book, The Mediation Minute, began simply as observations about what he was seeing in mediation rooms and the psychology of dispute resolution. Sharing your insights through writing, speaking, or teaching allows people to understand how you think and how you approach your work. And finally, trust is the foundation of dispute resolution. Parties will only open up, share information, and move toward resolution when they trust the process and the neutral guiding them through it. Before you all go, if this episode gave you an idea or insight you can use in your own practice, please take a moment to follow the podcast and share it with a colleague who might benefit from this conversation. Until next time, everyone, keep building the practice and the career you truly want, and I'll see you in the next episode of the Practice Playbook podcast. Thanks so much for listening to the Practice Playbook podcast. If you enjoyed today's episode, I would love it if you'd take a moment to leave a review, follow the show, or share it with a colleague who's ready to build the practice of their dreams. If you want more support and tools like the ones you heard today, join the waitlist for the Practice Accelerator, my brand new subscription program packed with resources to help you grow smarter. You can find the link in the show notes or visit susaneguthrie.com to learn more. Until next time, stay focused, stay intentional, and remember, success starts with the right playbook.